We are going to have a really interesting panel here on the Gulf oil spill settlement with Brian Israel from Ardell and Porter, who represented BP in the matter, John Cruden, the aforementioned eminent statesman in the settlement world, longtime head of the both career and then political, head of the Environment and Natural Resources Division for the Justice Department, and also Billy Plosh from the state perspective. I will say, just by way of a personal mention here, I was the Deputy Secretary of the Interior when the Gulf oil spill happened, and was the first administration official down in the Gulf the morning after. It was my youngest daughter's birthday. Ken Salazar sent a note to her apologizing that Dad would not be home. Didn't bring any underwear, bought some at the Kmart, was down there till a couple days to watch the rig sink, and then for the next 87 days, Ken Salazar and I, every 9 a.m., 9 o'clock in the morning, met with the top BP official in charge of the cleanup, and suffered through quite an experience, including 3 times a week in the Situation Room in the White House. But I was the client, I was not the lawyer. The lawyers took over and did some really interesting things we're about to hear about. So, Brian?
Thank you, David. I was there just a few days after you. It was the end of April 2010 when I was in Houma, Louisiana, and watched as the Environmental Command Center grew from a few hundred people to, well, ultimately throughout the Gulf, there were 47,000 people working on the response in the summer of 2010. That's a company the size of IBM, formed in a matter of weeks, and it was quite an experience. I'm going to focus, it's interesting, we have Billy representing, at the time, the state of Louisiana, and John, of course, the United States, and they somehow agreed that BP could go first, so here we go. So this is my perspective, and I'm sure they'll be able to add their commentary. I'm going to just give a slight overview of the environmental settlement, which was the largest settlement in the history of the United States, and I may have a detour or two with a few comments. But just to set the table, the key dates, it's a little hard for me to read and speak to you, but the incident itself, the explosion at the Deepwater Horizon rig occurred in April 20th of 2010. April 21st, David Hayes shows up. April 29th, I show up. And of course, the immediate issue is the terrible loss of life and recovery efforts. And then we all pivoted to, and not me, but the company and the government tried to figure out how to stop the well from gushing. And I'm sure you all recall the daily CNN reports with oil coming out of the bottom of the ocean. The rig was 40 miles offshore of Louisiana and a mile deep. The conditions were really almost impossible to work in. It would be like trying to do an operation on the moon in terms of the ability to stop the gushing oil from the bottom of the ocean. You might remember every week there was a new technology that was being experimented with, a top kill, top hat, all sorts of things, and all of us were watching very intently, of course, and praying that the well would be plugged. Ultimately, it was through the use of a second well that was dug, and then went in and installed concrete. So I'm not going to talk too much more about the technology of how that was done because I don't really understand it myself. In December, the United States filed its lawsuit, and John's going to speak to that, alleging Clean Water Act violations as well as Oil Pollution Act. In April, a year later, I want to pause and talk about a partial settlement. A year after the spill, BP and the United States and the 5 Gulf states, Texas, Louisiana, Mississippi, Alabama, and Florida, agreed to something called an Early Restoration Agreement, or it was called formerly the Early Restoration Framework Agreement. And the idea was simply this. We all knew that there was going to be major environmental impact in the Gulf of Mexico. And we knew that BP was going to be responsible for restoring the damages caused to the environment. But we also knew, because we practiced in this field called natural resource damages, that it could take many, many years to fully understand what those impacts would be. And so we agreed, completely outside of the regulations and outside of the precedent or any other examples, to an early restoration agreement. And BP agreed to fund $1 billion for restoration projects to get ahead of the assessment, to do this work in advance of completing the environmental assessment. BP did this because, for many reasons, but one of the reasons is because under the law, they would be responsible for restoring the environment to its baseline condition, but also any interim losses. So if there's a loss of habitat for the course of years, they would be responsible for those interim losses. In addition to that, of course, and I think we were all motivated by the fact that the public was not willing to wait. This was not an option. We needed to get people on the ground doing actual restoration work. And so this really neat agreement was negotiated, and it allowed for the parties to decide on projects, decide on the cost of the projects, and then ultimately what credit BP would receive at the end of the day, either in a settlement or in a judgment, against any damages that were found. It was very hard to negotiate BP vis-a-vis the governments, but Billy will probably point out it was equally as hard, if not more so, to negotiate amongst the states, because there was competition for that $1 billion, as you might imagine. So as part of the assessment, we spent meaning the government and BP, spent over $1 billion simply doing environmental assessment. The environmental investigation after Deepwater Horizon was the largest environmental investigation ever undertaken in the history of the world related to an environmental incident. I think the only thing that might rival it is the investigation over climate change. And this is an amazing commitment of resources, and it's probably fair to say that the Gulf of Mexico is one of the best understood ecosystems now in the world, certainly much better understood than it was before 2010. We undertook over 200 cooperative studies, meaning BP and the trustees would go out into the field and take data on water columns, sediment, corals, birds, dolphins, manatees, whales, wetlands, all sorts of, 1 million different bird species, et cetera. The database is all this data now is available online. It's terabytes, which is a word I hadn't been familiar with before this undertaking, terabytes worth of data. One of the things that I'm just going to take a quick detour that we needed to understand is the baseline conditions. What were the conditions before the oil spill? And one thing that complicated that is the fact that there are hundreds and hundreds of natural oil seeps at the bottom of the Gulf of Mexico. In fact, the reason we being society, to explore for oil in the Gulf of Mexico is because there's oil on the beaches in Alabama, in Texas, in Louisiana, from natural occurring tar balls. If anybody's been to the beach in Galveston, for instance, when you leave the beach, there's a little station where you put mineral spirits on your feet so that you clean your feet before you go home. So we needed to understand that. And so this is just a map of known oil seeps in 2010. This is an interesting video. So those little white canisters are sediment containers. So this is a mission that went down to the bottom of the seafloor to determine what impacts were in the ocean. If you could hit the video, you can see.
Unfortunately, it's not a video file.
Well, you can't see. So gushing out of you can see if you could see it, and I'll send it to you if you send me an email. You can, there's oil gushing out. The sediment canisters were being videotaped because that was part of the study, and you could see oil gushing out. And that was just an example of naturally occurring oil seeps. The next slide probably also not going to work. Let's try it. You got the new video, the new PowerPoint up?
Yeah, this is the latest one.
Okay, it's also not working? Okay. Well, I'll just describe. So what it turned out was happening. The other question that we were confronted with is there was a lot of hundreds of millions of gallons of oil released from the well, or I might be precisely incorrect about the number, but in any event, lots of oil, and a lot of oil on the shoreline, but not nearly enough oil on the shoreline to explain how much oil was released. And one of the questions we were all confronted with, the scientists, were what was happening, where's the oil? And one of the things that the scientists rather, discovered was, or knew, but understood better, was a phenomenon called biodegradation. And this is a very nifty animation that was prepared for trial that shows exactly how biodegradation works. And essentially, the molecules of oil were emanating from the well. There were dispersants added to disperse the molecules into small molecules of oil. And then microbes or bacteria would consume the hydrocarbons. And essentially, we came to appreciate that the Gulf of Mexico is a hydrocarbon ecosystem. It has an entire trophic level that relies upon hydrocarbons, has evolved over millions of years. And they were very, very happy microbes during 2010. And we could, what happens, they eat the hydrocarbons, and then all that's left from that is water and carbon dioxide and no oil, no hydrocarbons. And the scientists were able to find this phenomena. You can't find the absence of hydrocarbons, but you could find a low dissolved oxygen. And so that was the NOAA cruise ships would go out and find low dissolved oxygen, and that's how they knew that the biodegradation was occurring. And I promise it's a very cute video, and it describes everything I just said. So let me just continue the detour for one more minute, and then I'll get back to the settlement. There's a big problem in cases like this between what I call myths and facts, or fears and facts. And everybody, including me and everybody involved in this, was very, very worried that we were witnessing the collapse of the ecosystem in the Gulf of Mexico. Much of our experience was driven by Exxon Valdez, which was happening in an environment that doesn't have biodegradation and a release of oil from a ship, so at the surface. And this was a much different circumstance. And these are just a couple of examples, if you will, of things that people were afraid of. So this, with respect to fish, and these are quotes not from BP. These are quotes from either government officials or academics. So in April of 2010, people were saying things like, there's no question the fishery population are going to be set back. That was a reasonable thing to say. But yet a year later, not in this case, not even a year later, from the government, a researcher said, the data don't show any large-scale effects that we can detect. It's quite amazing. Everyone speculated an entire year class of larvae might have been lost, and it hasn't happened. Here's another example with shrimp, and this is really important for Billy's client. It's very, very scary. It could, said somebody from the Southern Shrimp Alliance, it could be 1 year, 2 years, or 40 years before Gulf shrimp is fully available. And then a year later, somebody from the Louisiana Department of Wildlife said, we can't say we've seen anything that we can without a doubt say is exposure related. Here's an example on birds. Now, I'm not at all, by the way, saying that birds weren't, or any animals weren't harmed. There was significant harm in the Gulf of Mexico. And many birds, many thousands of birds were killed. And that is obviously one bird is too many. But what was happening was far less than people feared because of the biodegradation and because of the cleanup efforts and because of the environmental conditions. Compared to a few thousand birds that were killed in deep water, there were over 40,000 birds that were found in the Exxon Valdez case, and over 250,000 birds that were calculated to have been killed in Exxon. So it's a very different scale. And this slide speaks to that. The spill spells disaster for birds in 2010 and 2011. 2011 will go down as the most productive since Katrina for nesting, according to the Fish and Wildlife Service employee. Again, I expect pelicans will get pretty hammered in 2010. 2011, the Pelican has made a terrific comeback. Just one more example. Tourism is an area where the impacts were far greater than Exxon Valdez for obvious reasons. There weren't a lot of people going to Alaska for tourism, relatively speaking, but a lot of people go to the Gulf of Mexico. And 88,000, bet you didn't know this, 88,000 square miles of the Gulf of Mexico were shut down during the summer of 2010 to fishing. And many, many beaches were closed. So there was a very profound impact to tourism. But even here, there was a very rapid rebound. So in 2010, experts said tourism and leisure was a sector that was just trying to get back on its feet. A hit like this could delay its recovery for several years. A year later, the visitors prove Panama City Beach is back. The good news is, in addition to being 51% up from last year, which of course is obvious since the beaches were closed the year before, but they were 28% up from the next highest month ever. Another example, in 2010, the state's dependence on tourism and jobs is significant, and a worsening disaster could likely have long-term implications. A year later, the Emerald Coast had its best June, July, August, and September months ever. So this is, in a way, it's kind of obvious. The beaches were very, very clean at this point. They were cleaner than they'd ever been because there was all sorts of machinery on the beaches cleaning them. But more importantly, a lot of Americans didn't really know that you could go to the Gulf of Mexico and that there were even beaches in the Gulf of Mexico in some parts. And after a year of this, not advertising, of course, but a year of news about the Gulf of Mexico beaches, a lot of people thought, oh, wow, I didn't know that could go down there. So that's that, and of course the rebounding economy and many other factors. Here's a picture. This is a terrible picture of Destin, Florida in September 2010 at the height of the spill. The oil actually had stopped by this point, but it had stopped gushing from the well, but it was still reaching the shoreline. So the exact same beach a year later, and you can see it's nice and clean, and there's people enjoying. By the way, just another little fun fact. The reason we have all these pictures is because for 4 years or something, we were part of the environmental investigation. There were airplanes flying the entire Gulf from Florida to Texas, taking high-resolution aerial photography because we needed to know how many people use these beaches. That was going to be part of the damages claim. Okay, back to the regularly scheduled program. Key dates.
Quickly, Brian.
Okay, I'm almost done. November 15th, 2010, there was a criminal plea agreement, a $4 billion penalty. 2.4 went to Gulf Restoration. In February 2015, the court concluded its Clean Water Act trial. But before the court issued a verdict or a penalty, there was an agreement announced in July of 2015 that covered natural resource damages and the Clean Water Act penalty. The consent decree was lodged in October. So the elements of this settlement, there was $5.5 billion as a civil penalty under the Clean Water Act. 80% of that penalty was under something called the Restore Act, which was an act of Congress that was passed in something like 2012, provided, unlike every other Clean Water Act case, that the penalties would go back to the Gulf of Mexico, 80%, for restoration projects. Normally, the penalties under a Clean Water Act go to the U.S. Treasury. The one feature of the settlement is that it included a very long payment plan because the numbers were so enormous that the government was demanding. We were able to negotiate an understanding as to the payment schedule. So it's still very large payments every year, almost $400 million, but the payment is spread out over 15 years. On the NRD side, the settlement was $8.1 billion, which included that $1 billion of early restoration. An interesting feature that's probably worth talking about as a group is this settlement has no what's called reopener, meaning that the government can't come back later and ask for more money, unlike most NRD settlements, including Exxon Valdez, and ask for more money if they find additional harm in the future. And in lieu of a reopener, there was an adaptive management fund, about $700 million. That was really important to BP because they wanted to be done. They wanted finality, understandably. And so that was something that was negotiated as part of this settlement. Also a long payment term. And then finally, there was a settlement simultaneous with this larger settlement with the state and local governments, almost $5 billion paid to the Gulf states collectively, and $1 billion paid to the municipalities. And this is just a pretty slide showing what I just described. So, sorry, David, if I went over my time, but now I'm going to ask for commentary and rebuttal from John and Billy.
Sorry, John. Spent most of my life in trial issues, so I'm incapable of sitting and talking to you. So I'm John Cruden. There, during this period of time, I was leading the Environment Division. I'm now in private practice. To start, though, I'm going to give a shout out to the panel following us for a particularly good reason. So you're going to get a super fun panel. It's going to be led by three of the wonderful people, all friends of mine, David Farr, Judge Firestone, Barry Breen. Why am I even saying that? Because you really can't understand what I'm about to talk about without understanding the Manual for Complex Litigation. If you understand that manual, it's based primarily on Superfund. The sequencing of Superfund and all those things. Several of us on Deepwater did a law review article at the University of Michigan. We call that Deepwater Horizon Proof of Concept for the Manual of Complex Litigation. What David has challenged me to do, which I'll do rather quickly, is to try to get lessons learned. So I'm not going to go into the various parts of the litigation. By the way, we did 500 depositions. There were 100 expert reports, so this is bigger than life, what we're talking about. But what I want to focus entirely on is give you my 8 or 10 points where I think these are lessons learned out of what was when Loretta Lynch announced it as the single largest settlement with a single defendant in the history of the United States. So all this is big, but I'm going to try to narrow it to things that I think are valuable in the future for all of us. So let me start out. First of all, you can't understand this without understanding the multi-district litigation practice. In these big, gigantic cases like this one, you have lawsuits filed across the United States for personal injury, for property damage, for economic issues. The MDL process picks not only where it's going to be, they pick the judge. So this one goes to New Orleans for the perfectly good reason that was the center of the injury issues there, and they picked Judge Barbier. And so you really need to understand that because all of these things then get consolidated and there are rules associated with that. Second, I already mentioned the Manual for Complex Litigation. Judge Barbier brings additional people in there. So almost immediately, you have an assigned federal magistrate for discovery purposes, but you have other players. You have special masters, special settlement masters. You have people actually advising on how you put together a case this big, where you have all these complaints, which he then structures. He structures the complaints into areas and forms and requires refiling the complaints. All this stuff, by the way, in the Manual for Complex Litigation. But there are other players now. One of my players was the former FBI Director Louis Freeh, who was in fact the settlement master. So we're communicating daily with him, trying to push not only the litigation there, which he is not involved in, but he's pushing settlement, and we're doing simultaneously. So there's litigation going on, and there's simultaneous other discussions going on. So MDL process and then players. And then finally, you have to kind of figure out in these big cases, who are you going to have to deal with there? I'm talking about BP, but there were various parts of BP. BP had a whole structure of companies and interlocking. United States is obviously a British company. The states, which I'll defer to Billy on that because he was leading this effort. Federal government, we had 5 agencies involved in all of that. I didn't need any help for Civil War. I could do it within the federal government anytime I wanted to on virtually every issue. So you're managing those things. And I'm confident that was true in tobacco. I'm confident that was true in all the vaccine issues. And it was certainly true here. there. And I think if you asked each one of us, we would all tell you about the internal issues that we were going through. I think very quickly in these sort of big cases, you have to seize control of the press. Who's going to speak? Because it's going to happen. One of the things that actually advanced us quite a bit in Deepwater is the judges. By the way, there are 2 failed settlement agreements before. This is the 3rd agreement. The judges, being very aware of that, gave us very strict confidentiality. When I say strict, it was person by person. You went to the court to say, I want to add Billy Plauché to my negotiating team. A judge says, one at a time, that person signs and agrees to the confidentiality because you couldn't do it elsewhere. The give and take was just too hard, and it was too hard politically if, in fact, all of this stuff, as you're going back and forth, was going to be public. I'll come to the public part later on. So the parties were important, the confidentiality. Only then do I get to the terms of these agreements. And I do think in these cases, these big cases we're talking about, and I'll see you later in Volkswagen, from a government perspective, it was extremely important to have unanimity in at least the broad concept of what we wanted. Forget the dollar amount, just what do you want? In this case, it's true in a lot of environmental cases, we wanted enough money to bring the Gulf back to where it would have been but for the polluting event. And that's what Brian already talked to you about, the concept of natural resource damages. Second, the government had spent money. By the way, BP reimbursed most of it, but there was still some leftover money. We wanted to be reimbursed for all that. And then finally, there's going to be a penalty component there. So we knew conceptually what we wanted from the very outset. Then we had to bring in all the parties. We had to bring in, first of all the people on our side, federal government and state, and the various state elements. Then we're presenting, first of all, conceptually to BP, and then finally the specific numbers. But I think the clarity of what you want, which is not simple. Finally, then, how do you handle this? How do you handle these big, gigantic cases? I spent, most of my litigating life at the Department of Justice in a leadership role where I actually did not like agreements in principle. I've said, and I've said it publicly very often, I don't like them because it means I had to do everything twice. The agreement in principle is not binding, and then so you get done with that, and then you got to turn over and do another thing. Very often it went public. You had to deal with all of that. And so I was against it. Not in these cases. In these sort of big cases, you almost have to because it's so big. There's so many different parts to all that. And we did it here too. We did it an agreement in principle there, and almost simultaneously we're working on the consent decree. But you actually have to figure out how do you sequence a settlement when you have that many parties, that many moving parts. We had experts for settlement, for sure. We had experts for trial, because remember, we had 3 trials in this particular case. But for settlement, we also had experts. Why do you need experts for settlement? Well, first of all, they're not going to, companies not going to admit liability. None of the consent decrees we did at Department of Justice required an admission of liability. But you do have to convince them that you're correct. And we're north of $20 billion, which is a fair amount of money there. So we needed that. But also, and true in all these big cases, we needed to be able to judge the economic ability of the company. No matter what anybody says there, every company does not want to go out of business, and we needed to know what that meant. And so I assure you, by the time that we finished, we knew a lot about BP finances because we're not trying to put them out of business. But absolutely, we're not trying to put them out of business, but we needed to know what would affect them, and that affected in our negotiations how long we gave them to comply with the settlement because we're not trying again to end their viability. Next, so that's experts, we use them. Then, what do you need to approve it? You actually have to think ahead. Who is going to approve this at the end, and what are you going to have to do for the approval? At the end of the time that we had a consent decree filed in October, we required every governor of the 5 states and every attorney general of the 5 states to personally sign the consent decree. We thought that gave us some solace that maybe it would all happen there. But it's true in the federal government side, too. We had 5 sort of cabinet secretaries who were all involved in some other way, and they needed to personally approve all of that. In addition to that, we needed to do an environmental impact statement. We needed to have a natural resource damage governance. You know, one of the questions we were debating here in this panel is, how do you make sure the money gets spent the way you want it to be spent there? And the concept of natural resource damages by statute, but also by our agreement, it could only be used, magical language, restore, replace, or acquire equivalent resources. So it was limited by that. But that meant you needed a governance structure. By the way, just for fun, you heard already from Brian that we really had the agreement in principle, say, May, June of that year. In October, we filed an environmental impact statement. We had, in May or June of that year, nothing, 0. So think about that, those of you who do NEPA litigation. May or June, nothing. October, file environmental impact statement. I've always been quite proud of that there. But who has to approve it? What do you have to do and all that? That's another one. Now, Congress. I've often said environmental law is largely born of tragedy. So Exxon Valdez, which is how I started my career, is on Exxon. That gave us the Oil Pollution Act. Deepwater Horizon gives us the Restore Act. And you've already heard from Brian that unique part about that is 80% of the penalties went to restoration. It also set up a bureaucratic process. But my point is, in these big cases, Congress is involved. They're public. They want to know things. They want testimony. They want reports. And that's just part of what you do in these cases. And it's certainly true if you're a government entity. States, I know, they were reporting to their own legislature. It's just another complicating factor. You heard, again, Ken Feinberg, who I treasure. I've been with him on a number of cases now, talk about what to do with latent defects, things that you cannot actually envision in that case. When I did Exxon, we had something called a reopener, which means if you didn't figure it out and was all new, then you could apply for another $100 million there. Not what we did in Deepwater. Deepwater, we did not have to apply. Deepwater, $700 million was set aside for things that we could not figure out and could not anticipate. That would be available at the end of the process, but we could use it beforehand if we needed it. But you don't have to apply it. It was part of the agreement there. Last point of my group, and that is, so particularly in environmental issues, we have this incredible process for how does the public get involved. So at the end of our time, we quote, lodge a consent decree. And we tell the judge, Judge Barbier, don't do anything with this. It's press, it's public, but it's not done. We had 8 public hearings. We went in the 5 Gulf states. We went I ran the one in D.C. where everybody got to come in and say whatever they wanted about that. Many people thought the project should be in their area, not surprisingly, there. But nonetheless, we go through that very highly public process, and then only at the end of that do you go back to the court and say, we've heard everything. Here's, if we wanted to change something, you could, if everybody agreed, you could do it. But you have the quote, enter the consent decree. And the significance of that is it becomes a judicial order. Theoretically, we did not have to do that. In this case, theoretically, if BP had not paid the money or had not done what we wanted to, you could seek contempt of court. And so that became a very powerful entity, but it also brought the public involved because the public did not need lawyers. You could do this stuff on postcards if you wanted to. They got involved, but they were not involved clearly in the negotiating process. Those are my top 10. Billy, what about the states?
Thanks, John. Well, let me. I'll kind of reconfigure things. I had 3 or 4 things I want to touch on. I'll reconfigure them a little to respond to Brian, as I like to do. So first thing, just a couple of kind of key takeaways from my perspective on this settlement agreement. One was the people that are in the room are critical for getting the settlement done. And I'm laughing because I'm looking at, I've seen that first part of Brian's presentation before, as you might note, as you might guess. It was one of the early settlement negotiations. I think that was one of BP's presentations where we were, actually, we may not have even, that may have been an attempt to start negotiations that didn't take. Because I think the presentation kind of rolled through, and the ultimate conclusion was when you roll up all the dollars from the natural resource damages, it's about $500 million. We've paid you $1 billion, so you owe us $500 million. So, so after a couple of failed attempts at settlement, what finally worked was getting the folks in the room at least to start the discussion, getting the litigators out of the room. And I'll say it was sort of astounding when those discussions started, how little there was about the actual amount of liability. I mean, we had been slogging it out for 5 years at that point, and everybody knew everybody else's points really well, and we just didn't need to get into it. And it was about getting a deal that could work for everybody. And so it was interesting, in terms of people in the room, really heavy involvement from Magistrate Shushan, really heavy involvement from two other special master neutrals, Pat Juneau and Louis Free. And those folks were really active. They worked tirelessly, weekends and evenings, really pushing to get that deal done. And said having those sort of very activated neutrals, that was the first of the attempts that had that, and I think that was a critical component. Another critical component was John, not to build his ego anymore after Mr. Feinberg kind of already talked him up, but John, his initial involvement in the Deepwater Horizon spill, as he said, was as a career deputy, kind of working on the ground to get the team set up to get things moving forward. He then left and went into the nonprofit world and then came back as a political appointee that was heading the Environment Division of the Justice Department. But because he had that role as a career person on the ground, working with all the states, he had built very good, trusting relationships with the states. That, you know, a lot of the tension in the previous negotiations was a lot of distrust amongst the states. And having somebody that everybody could kind of buy into and kind of felt like wasn't going to screw them, was really important as a kind of getting all of those different parties together. And then Brian also, as I hate to say it, Brian also was a critical component of that as well. Brian, as part of the early restoration agreement, I'll talk a little bit more about that, we had been, the states and federal trustee agencies had been negotiating with BP on these restoration projects for a couple of years and had really, had some acrimonious times, but had sorted through getting some really good projects on the ground. And I think had built a level of mutual respect for each other that kind of helped facilitate things. And when it came time to bring the lawyers in to structure the deal, BP didn't bring their litigators in. They brought in, or they didn't bring Kirkland and Ellis had been doing their litigation. They brought Brian in to kind of work on that deal point. And I think the experience with the other parties and kind of working through some of those tough issues was critical. So getting the right people in the room was I think the number one element to success. Second, I just want to touch on, John talked about this a little bit, but the level of inherent internal tension on the government side of this, the case and the agreement was kind of astounding. As John said, he had 4 federal trustees that he was working with. You usually only have 2, DOI and NOAA. Here, the president, in his wisdom, appointed 2 additional federal trustees. So we had EPA and USDA. So he had 4 federal agencies plus the Department of Justice. Then on the state side, each state had their governor and their attorney general, both elected statewide, sometimes not even in the same political party. Louisiana had a Republican governor and Democratic attorney general, and with very unclear lines of authority, particularly when it came to natural resource damages, on who had control of what. And so that was an inherent tension within each of the states. And then you had, within just the state agency side of things, John had 4 trustees. We had 5 trustees in the state of Louisiana. So replicate that, through the other 5 Gulf states, and you just had a ton of governmental agencies and entities that needed to be brought along. And then Brian talked a little bit about the buckets of the settlement. Each of the states had different sort of perspectives on where they wanted money to go in those different buckets. Louisiana really wanted the NRD bucket to be heavy because Louisiana was really focused on coastal restoration, and NRD dollars had to go toward restoration. They were impact-based allocated, so they were allocated based on where the injury was, and Louisiana suffered the brunt of the injury. I'll talk a little bit more about that. So having that, having money allocated to the NRD bucket was critical. Alabama and Mississippi, they really wanted money allocated to the restore bucket, because the restore bucket had, it took those clean, that 80% of those Clean Water Act penalties, it distributed some of it pro rata, it distributed some of it based on impact, and then it distributed some of it based on the sort of discretion of the council, which could be done by a 3-state majority. So they felt like they had a lot more flexibility on the spend if they could put money into that Clean Water Act penalty bucket. And then Florida, who suffered probably primarily economic damages, really wanted to put money into that economic damages bucket, because if they could put it there, they didn't have any guidelines or regulations on how they spent it. They could put that into their treasury and spend it without a lot of control and a lot of anybody else saying anything. And so you had these different tensions among the states trying to put things in different buckets. So all of that had to get pulled together, and I think it was in the course of about 2 months that we got to the agreement in principle. So it was quite a feat to finally get those things pulled together. Third, I want to just touch on briefly on the early restoration agreement that Brian talked about. I think everybody agreed in the end, although there was a lot of kicking and screaming along the way, everybody agreed in the end that was a great agreement that did allow some restoration projects to get started earlier than they would have, start some what were some really big and critical projects in the Gulf. There were 2 aspects of that agreement that I think were really helpful also in helping us figure out how to structure the ultimate settlement agreement. One, Brian talked about the negotiation of offsets. Those offset negotiations were very difficult. It was basically trying to figure out, before you've done the injury assessment, before you've even decided what metrics you're going to use to quantify injury, you've got to negotiate with BP what their offsets against that injury is going to be. So, tying that precise linkage of restoration to injury is really challenging. The science is kind of there, but not really there to the mathematical certainty that you'd like it to be for these kinds of dollar negotiations. So what that led to in the ultimate settlement agreement was the trustees decided not to look specifically at species by species, this many birds, this many fish, that sort of thing, but instead looked at the entirety of the ecological injury. Basically said this is an ecosystem-wide disruption, and so we're going to look at ecosystem-wide restoration projects, and we're going to put restoration dollars into categories that are going to restore the ecosystem. So that experience helped us get away from that checks and balance of that precise checks and balance of species specific. The other thing it did was, as Brian alluded, the challenges amongst the states of allocating that $1 billion was we didn't get any negotiations going really for about 9 months after we entered that $1 billion agreement, because no state wanted to agree to any other state's use of our federal trustees' use of those dollars until they knew what they were going to get out of those dollars. So we had a 3-day lock the rooms and lock everybody in a room in Gulfport, Mississippi, negotiation with all of the trustees where we allocated out that $1 billion, and it was incredibly painful. I think 2 of the trustees still don't speak to each other after that, from the fallout from that meeting. But that led us again in the final settlement agreement to come up with a structure that, as part of the settlement, allocated dollars to these 7 geographic areas and said, we're going to put this many dollars in these categories of restoration in Texas and Louisiana and Mississippi, Alabama, Florida, open oceans, and then some in a region-wide bucket, and basically get everybody largely out of everybody else's business. So that was I think it was a great lesson learned on the early restoration agreement. Let's see, the other thing I want to touch on briefly is just the Restore Act. Brian talked about it, John talked about it a little bit. The Restore Act, I think at the time, folks the idea was, barring some legislation, all of these dollars in civil penalties, billions and billions of dollars, are going to go into the Oil Spill Liability Trust Fund and just sit there to help respond to future spills. And is that really the best use of the money? Is that really what was envisioned when OPA was created, a spill of this magnitude? And Congress decided they wanted to use that money, take at least 80% of that money and use it for things that could happen on the ground. It was, as any legislation, it was a making of sausage, and so everybody got a little something out of that deal. And so there's all these different buckets within the Restore Act. There's a new bureaucracy that's set up to sort of allocate dollars. I think, and John and I were talking about this a little bit over breakfast, my perspective is we probably, using some of the existing tools like supplemental environmental projects and things like that, could have done a lot of what the Restore Act did, could have used a lot of that money for things other than the Oil Spill Liability Trust Fund without the Restore Act, and probably could have done it without establishing a new bureaucracy and without some of the giveaways that had to happen towards, you know, economic projects and things like that. So it's a mixed bag. I mean, I think at the time there was a lot of rhetoric about making sure that these penalties go to the states, and the reality of a negotiation is always a little more complicated. But I think, you know, I at least, I think in Louisiana, we at least question whether the Restore Act was really that necessary. And then final thing I just want to touch on is just the importance in the negotiations of kind of walking in with your story. Brian had his story up here, your story and your vision. Louisiana as I said, was the brunt of the oil, suffered the brunt of the injuries from the oil spill. 90+% of the heavily oiled shorelines were in Louisiana. So we really had a vision of putting as much of the money as we could into a NRD bucket, and as much of that money as could possibly go to Louisiana restoration projects. Louisiana also suffers a massive kind of environmental coastal crisis where they lose a football field to coastline every 90 minutes. They've lost 1,700 square miles of coastline since the 1930s. So this oil spill happened in an environment that was incredibly fragile and already significantly suffering. And so we really wanted to get that money put into restoring that ecosystem. Louisiana's estuaries also serve as, they're the nurseries of the Gulf. They serve as breeding grounds or kind of juvenile foraging grounds for 70% of the species that ultimately go in the northern Gulf. And so this idea of ecosystem restoration, we really got behind and wanted to push. Ecosystem restoration is restoring Louisiana's estuaries. Louisiana had a coastal master plan before the BP oil spill that's a scientifically based document, 50-year, $50 billion plan of restoration projects to restore Louisiana's coastal area. So we went into these negotiations with a plan. This is where we want to spend these dollars. This is if you want dollars to go toward restoring the Gulf, which everybody did, the best use of those dollars is to put them into NRD and put them into Louisiana's coastal master plan, do projects in Louisiana's coastal master plan. And that really rang, I think, with the neutrals. And ultimately, Louisiana was able to pull in, I think, ultimately $8.8 billion versus $5.5 billion that went to the Clean Water Act settlement. 8.8 went to NRD, and of that allocated portion of that 8.8, which was about $8.1 billion, about $5 billion of that is going to Louisiana and is actually funding now. We're working on a couple of massive $1 billion plus sediment diversions to get sediment back into the estuaries to reverse coastal erosion down in Louisiana. So, you know, having that story and being able to tell a compelling story was really helpful in those negotiations.
All right, that's terrific. So here's what we're going to do on the schedule. We're a little behind, but I want us to spend close to 10 minutes on this, and then I'm going to ask everyone to get their lunch and come right back here. So that Cheryl can give her remarks at 12:40 sharp, if that will work, and we'll just adjust accordingly. This is an amazing discussion. Let me just give one quick reference. John mentioned this Michigan Journal of Environmental and Administrative Law piece. I really recommend it to you. This is a very thorough discussion of many of the points that John mentioned here very briefly. So it's the Michigan Journal of Environmental and Administrative Law. The fall 2016 edition has a long article entitled "The Deepwater Oil Spill Litigation, Proof of Concept for the Manual of Complex Litigation and the 2015 Amendments to the Federal Rules of Civil Procedure." So all of you are nerdy enough to want to grab that as soon as you can. Let me ask a question. I'll make a few observations at the end of the day about this settlement. Is really interesting. There was a whole nother side of this, of course, Governor Bobby Jindal being not very helpful to Thad Allen and the rest of us about building islands in the Gulf and that sort of thing. I really wish I had been a lawyer again at that point. But there was another side of this that Ken referenced, the personal injury side. How did that fit into this or not?
Well, was he referencing the personal injury or the personal property damage?
Well, the property, I
Yep.
meant that I'm,
So there was-
I'm
yeah.
thinking broadly here.
So there was a claims facility, as required by OPA, there was a claims facility immediately established after the oil spill to help people that were injured by the spill. And that ultimately became Ken Feinberg's operation. And then once that was, and then that kind of evolved to a settlements program. And there was I think an $8 billion settlement program that was established only for personal private injury. So if you were a business operator, a hotel or whatever in the Gulf of Mexico, a fisher, an angler, in any way impacted, then you could assert a claim. And that settlement agreement became somewhat controversial over time because it did not have, or it had a relaxed causation requirement. So if you just fell into a category, like you were within a certain geographic area, and you could show that you had a reduced income in 2011 from 2010, then you could assert a claim, and you didn't have to show that that loss was related or caused by the oil spill. And that, frankly, has resulted in a failed, really not a very positive story with respect to part of the Deepwater Horizon legacy. And there are probably many, many lessons to be learned from that. But the litigation with respect to the private party settlement is ongoing because of claims and contests related to claims. And there's issues to this day that are in the Fifth Circuit, go to the Fifth Circuit, weekly. So that's a discussion for another day, but it is important. I'm glad you point out that that's completely unrelated to this environmental settlement.
Questions?
But it makes a good point.
Yeah.
All of us are coming into these cases looking at our piece of it. So I'm looking at the government piece. I can't settle without Billy. I can't settle without him. But the judge is seeing more. The judge is seeing the personal injury. There's a criminal case that's going on parallel to some of this in the beginning. It settles beforehand, so we're not talking about it. But those things are happening. There's implications for the company. There's a debarment and suspension issue out there. And so to be effective in these settlement negotiations, you really have to understand each and every one of the various parts, even though your part might be more narrow and limited there. And that's one of the values of that Brian brought to this because he was actually seeing the entire picture for BP.
Yeah, this was a narrow $20 billion piece of it, so, yes.
Now, go ahead.
So I want to understand a little bit more about the $1 billion early restoration fund. I'm clearly missing something. Was it tough because the question was how to divvy up the billion, or was BP looking for something other than purely set off against future dollar?
Well, so I'll take the first crack, and then it was tough because of both. So $1 billion, the parties agree, up to $1 billion is going to be spent on restoration. Now we're going to go forth and we're going to negotiate projects. Which projects do you want to do? So we have to agree. It can't be something with respect to killer whales where there's no injury, or it has to be somehow caused by and linked to the injury. It has to be, we have to agree on what the project is. We have to agree on what the cost will be. It was very important to BP that, the money is being spent wisely. And then lastly, BP has to agree on what the credit will be and what currency that credit's going to be articulated in. So is it going to be articulated in number of birds, bird years, discounted bird years? Is it going to be in acres? Once you get into the NRD world, I'll spare you, but there are dozens and dozens of currencies that
It's not just money.
It's not money. So if you have a bird, you're trying to restore birds. How many birds are created by that project? and those birds have to be discounted into years. And then you have to decide, okay, well, this project, we all agree will create 1,000 bird years. And then, so that's the process. And every single project, there were 100 projects, every single one of them, before we get to the interstate competition, just with BP alone, with BP, every single one of those projects has to be negotiated, and all of those currencies have to be determined. Some cases you have backup currency, so BP would agree, okay, we'll do an oyster hatchery. We don't think there's an oyster injury based on our research. We'll agree to an oyster injury, but only if you agree. If we're right and there's no oyster injury, we can still have that credit for some other resource. And so you can see just in that one example how mind-numbingly complex it gets very quickly, and it has to get replicated over and over again.
Yeah.
And then we turn to the states.
So I want Billy to talk about it because he led the allocation effort. I only say one thing. This is back to Ken Feinberg. Remember, Ken is challenging us in settlement. Be creative, be thoughtful. The problem is there was no legislative or regulatory direction on this, which is to say we made it up. There, it was a good thing to make up, right?
Yeah.
But nonetheless, the absence of having that structure created an enormous amount of implementation issues. Billy?
Yeah, and I just briefly, I mean, I think the one with the states is obvious. Everybody wanted that $1 billion. So it wasn't, Louisiana wasn't about to share it evenly, just split it up, whatever, $200 million each. They were more heavily impacted. And so it was, ultimately, we realized you couldn't incrementally take money out of that. You just had to take a swing at that entire pot and allocate it amongst the states, which was tough.
And the federal government, too, wanted resources.
Yeah,
So NOAA is worried about the deep blue sea and the corals and the things the states aren't that concerned about. I mean, they're concerned about it, but it's not their immediate issue. So everybody's competing for those early restoration dollars.
The interesting aspect of that is I think a lot of people think the NRD element, part of the Superfund law, has been largely a failure because it's such a slow motion effort that trustees spend years on. Is there been any progress on the Hudson River with GE, for example, and PCBs on the NRD? No. These guys, in the context of litigation, it all came together. They had to do it. There's some lessons there that would be great to go forward with.
One thing,
Yeah.
and this gets to John's comment, on the fact that there was not a regulatory hook to do early restoration, and that created a lot of angst and wasted time, I think. Part of the Department of Interior is currently looking to revise the NRD regulations in many respects, and one of the lessons learned is to create the regulatory vehicle that will allow for early restoration to be done much more quickly. Obviously, we have a precedent now in the future, because it really wasn't clear that what we were doing was legal. We tried to get around that by having stipulations with the court and having the court bless it, but it wasn't obvious at the outset that what we were doing. It made sense, but there wasn't a regulatory.
But it was creative and innovative.
It was creative and innovative.
But maybe not
Maybe not legal, but that's okay.
So we're gonna let's congratulate these folks for their job well done.